Welcome to episode 3 of the DFE Retailer Support webinar series, which we've designed to assist retailers to prepare for and respond to domestic and family violence in the workplace and support employees who may be experiencing domestic and family violence. My name is Lindsay and I'm part of the team at the National Retail Association. As the modern voice of retail in Australia, we represent and support employers in the retail and fast food industries with training and advice on employment-related matters, including supporting and managing workers experiencing and engaging in domestic and family violence. This webinar has been created to assist employers with understanding how to manage health and safety in the workplace and what steps you should take as an employer to ensure the safety of your employees and others in the workplace when it comes to domestic and family violence. To begin with, it's important to understand the legislative framework for work health and safety law in Australia. In general, the legislation in place across Australia is substantially the same since the introduction of the model work health and safety laws in 2011. While the legislation is all largely similar in each jurisdiction, you should ensure that you understand and refer to the legislation that applies in the relevant state or territory of your retail operation. In Queensland, this would be the Work Health and Safety Act 2011. Work health and safety legislation uses the concept of a person conducting a business or undertaking, abbreviated to PCBU, when talking about entities or individuals which engage workers. But for our purposes in today's webinar, we will just say employers. An essential element of work health and safety law is that it creates a legislated primary duty of care for employers. This can be found in Section 19 of the Queensland legislation. The primary duty of care requires employers to ensure, so far as is reasonably practicable, the health and safety of workers. Employers owe this duty to workers rather than employees. In addition to employees, the concept or term worker captures individuals including volunteers, students, apprentices, subcontractors, and outworkers. And notably, this duty of care extends to preventing harm to workers by non-workers. So, for example, employers should consider and put in place precautions to ensure the health and safety of workers from customers who try to assault employees or robberies. In the domestic violence context, this could include protecting workers from family members or partners who come into the workplace to perpetrate violence. To fulfill this duty, employers may put in place procedures and training on what to do in response to an incident like the ones I've just described occurring. Importantly, for employees experiencing domestic and family violence, the duty of care extends to ensuring health and safety from a partner, ex-partner, or a family member. Officers, including directors, company secretaries, and senior managers or executives of a business, have a separate duty under Section 27 of the Queensland legislation to ensure that the business discharges this primary duty of care. This is also called the duty of due diligence and requires that officers of a business acquire and keep up-to-date knowledge of health and safety matters, understand the nature of the operations of the business and the hazards and risks associated with those operations, to ensure that appropriate resources and processes are available and used to minimise or eliminate the risk of harm, and to ensure that there are appropriate processes in place to ensure the adequate receiving and consideration of information about potential hazards and risks. Officers will also usually be workers, particularly in the retail context, and workers also have certain duties and obligations in the legislation. Section 28 of the Queensland legislation requires workers to take reasonable care of their own health and safety and the health and safety of those around them. The most obvious significance of this is that it's difficult for an employer to take steps to ensure the health and safety of their workers experiencing family and domestic violence if the worker does not make the employer aware of the issue. As a consequence of this, a worker who is experiencing domestic and family violence, which has the potential to cause a health and safety risk at the workplace, should disclose that circumstance to their employer so that their employer is able to effectively manage the potential risk. That being said, while there is this duty, it's generally not easy for workers to disclose such an issue to their employer. We've talked about the challenges in earlier webinars, and where a business takes steps to create a workplace culture that is supportive of workers experiencing domestic and family violence, workers may feel more comfortable to disclose this. This allows businesses to take measures to ensure the health and safety of the worker and their colleagues in the context of domestic and family violence. There are obvious challenges with the blurring of lines between someone's personal life and their work life, and this has been further complicated in the modern age of technology. Work health and safety laws apply to the workplace, which is wherever the worker is engaged to perform work on behalf of the employer. This not only includes the employer's premises, it also includes places a worker is likely to be in connection with work, like the car park of their office building or retail store, the employer's vehicles, customer sites, for example, if the worker works on a mobile basis, or even the worker's home if they have to work remotely. Technology also makes it easier for perpetrators of domestic and family violence to engage in abusive conduct towards their partner or family member without being obviously present at the workplace. This means that you should also consider the potential for your email and phone systems to be used to put your workers at a risk of harm. You may want to consider matters like whether members of the public can directly call employees, whether phone numbers are available publicly, what your protocols are around providing personal information over the phone, and whether you should have a system to monitor emails in your workplace. Work health and safety law is focused on the identification and management of hazards and risks. A hazard is something that has a capacity to cause harm. A risk is the severity of that harm and the likelihood of it occurring. Family and domestic violence is not in and of itself a hazard. Rather, it's a factor that affects risk. For example, every customer that walks through the door of a store has the potential to physically or verbally abuse shop staff. This is the hazard that each customer represents. The risk that these customers represent, however, is heightened by such matters as whether they are intoxicated, whether they are in abusive domestic relationship with a member of staff. Although work health and safety law has only started to grapple with the concept of family and domestic violence relatively recently, there are some general circumstances in which it's commonly accepted that domestic and family violence falls within the ambit of work health and safety law. Some of the hazards that fall within the scope of work health and safety laws are physical or verbal abuse between partners employed at the same workplace, threats to a partner or to the partner's co-workers at the workplace, harassment or attacks on a partner or a partner's co-workers at their workplace, either in person or by communication mechanisms like email, phone, or text message, stalking someone at their workplace, and in the most extreme cases, family violence-related homicide at the workplace and mental health concerns arising from exposure to any of the above circumstances I've just talked about. It won't be immediately apparent in most cases whether a worker is experiencing domestic and family violence. And if an employee doesn't disclose this, an employer may be left to guess based on whether there are signs manifesting, like the ones we've mentioned in previous webinars. However, employers can take proactive steps towards a safer workplace. Employers should acknowledge through company policies, processes, and culture that domestic and family violence is a workplace issue and it's not acceptable. Employers should also communicate the support that's available to employees, including through health and safety representatives and employee assistance programs in the workplace. Employers can also provide all workers with education and training to raise their awareness of domestic and family violence and its potential impact in the workplace. Employers can also communicate the availability of entitlements like paid and unpaid leave and flexible work arrangements to support workers experiencing domestic and family violence. They can provide information about counselling, legal, health, and financial services that are available either through the employer or in the community more generally. And employers can provide a safe, secure, accessible reporting mechanism to allow employees to disclose issues in confidence when and if they arise. Where an employee does disclose that they're experiencing domestic and family violence, employers should consult with the worker in a confidential one-on-one conversation about their working arrangement and seek to identify any hazards or risks arising from their personal circumstances and ensure that disclosures of family and domestic violence are treated confidentially and that workers are assured of this confidentiality when the discussion occurs. However, working out what risks may be present may take some thoughtful consideration. When dealing with domestic and family violence in particular, the key risk areas are those where a worker is accessible, and this includes both physical and digital accessibility. When assessing these risks, businesses need to ask themselves, in what parts of the workplace are my employees accessible when they are at work? In what areas connected to the workplace are my employees accessible when they're at work? Places like the car park or back dock. Does my business have the ability to filter what telephone calls or email messages my employees receive? Any area in which an employee is accessible is an area in which domestic and family violence can be perpetrated against them. As an example, if an employee has a direct telephone line that's publicly available, this allows a perpetrator of domestic and family violence to contact the worker at work without any oversight by the employer. Measures of mitigating the risk of domestic and family violence, at least where the employee is not working from home, include ensuring that the premises are secure and entry is controlled to the extent possible. Areas inaccessible without the use of a code or security card, for example. Requiring visitors to register their details and having processes in place to ensure the prohibition of entry to specific individuals if the need arises. Separating workers from the public where possible, or providing a safe space where workers can separate themselves from the public in the event of an incident. Employers can ensure communication and alarm systems are in place when needed. And employers can develop and implement procedures for responding to incidents, including notifying employees when it's appropriate to call on police involvement. Employers can change work, telephone or email addresses if these have been used to perpetrate family and domestic violence, and implement a means of filtering communications. For example, emails from a specific email address may be redirected and telephone calls may be screened by a reception or a switchboard. Where employees are working from home, these measures are likely not able to be implemented, but there are some measures that can be put in place to assist in ensuring your employees' safety. These measures may include ensuring the constant lines of communication are available and able to be used, regularly checking in with the employee by telephone or other means of instantaneous communication. You could establish a code word to allow workers to indicate that they are in need of assistance, or you could appoint a contact person for the purpose of receiving concerns about domestic and family violence while people are working from home. Ultimately, everyone in the workplace has a duty of care to ensure the health and safety of one another. However, there are a number of factors that can complicate efforts to fulfill this duty, particularly where domestic and family violence is involved. However, by taking the time to consider how we can all be safer, we can improve the ability for people to remove themselves from abusive situations safely. If any of the discussions we have had today have raised questions about your health and safety obligations as an employer, please don't hesitate to call the team at the National Retail Association on 1800 445 522. And finally, if you or someone you know may be experiencing domestic and family violence, please seek support by calling the National Sexual Assault, Domestic and Family Violence Counselling Service on 1800-RESPECT or DV Connect on 1800 811 811 for women and 1800 600 636 for men.